As part of its ongoing role in support of the judicial network in Central and Eastern Europe, the Seeley Institute presents a series of seminars on remote judging, where we discuss and suggest best practices to guide judges as they come to grips with e-justice, fair trial rights, and international standards.
For us, this network of judges, rising judges from across Central and Eastern Europe, has been one of our flagship programs at the Institute for the past, I think, 8 years. The network was really designed to support the judiciaries across Central and Eastern Europe. We've worked with judicial associations in many of your countries. We've supported the development of tools, our social media guidelines, our manual on judicial standards, and other activities. We've supported in-country training events and in-country conferences. And we look forward to continuing that work even after the pandemic. My true hope is that when this pandemic is all said and done, I'll get to greet every one of you in person here in Prague. I really, really hope that day comes, and I hope it's not too far distant when we can all gather together in one place. I did want to also extend a special thank you to Judge Jeremy Fogel. Judge Fogel's background as the former director of the Federal Judicial Center in Washington, D.C. means that he comes to you with just an extraordinary background in judicial training. He really oversaw a lot of the programs for the entire U.S. federal judiciary. So I think his perspectives will be incredibly valuable tonight.
Just to summarize a little bit, Judge Jeremy Fogel was the first executive director of the Berkeley Judicial Institute, which was set up as a way of trying to encourage links and interaction between judges and academics, and to promote an ethical, resilient, and independent judiciary. And I think those are some of the things that he will be talking about this evening. Prior to that appointment, he was director of the Federal Judicial Center in Washington, D.C., as a United States District Judge for the Northern District of California, and as a judge of the Santa Clara County Superior and Municipal Courts, and founding directing attorney of the Mental Health Advocacy Project a number of years back. He's been a lecturer, faculty member, lecturer at Stanford Law School, and has received numerous accolades. I could go on and on. I think you can see the stature of the person that we have with us this evening. Radoslava similarly currently serves as a criminal judge. I know you made some introductions earlier on the Sofia Regional Court in Bulgaria, received her master's from Sofia University, is a member of a special working group on editing amendments to the new e-justice system, which is particularly relevant to this course, implemented to the Bulgarian courts, and is also a member of a special working group charged with looking at amendments to legislation which address matters of electronically summoning individuals for hearings and servicing legal acts. She's conducted research on electronic justice in Bulgaria and the US criminal procedures. So again, I can't think of anybody better to kick off the course for this. So Jeremy, if I start with you and hand over the floor to you for your presentation. Thank you so much.
Thank you very much. And let me just say again, what a pleasure it is to be with all of you. I really enjoyed the introductions and seeing so many judges from so many countries, and just what you said about what you're hoping to learn, because it really lines up very well with the experience of judges in the U.S. In this area, which I'm going to talk about a little bit, and what I've heard from judges in other countries as well that I've had the pleasure of talking with. And I think what I'll do is go back to late March and early April, which is when we started having serious outbreaks of COVID in our in our country, and there were places that went to lockdowns and so on fairly quickly, and the courts had to adapt very quickly as well. I'm going to talk mostly about the federal courts, but if you know about our system in the U.S., we have both federal courts and state courts, and actually the state courts do almost all of the work. They do well over 90% of the judicial work in the country. They do all of the domestic and juvenile and most of the civil, most of the criminal cases. The federal courts really are constitutional courts, and they do certain kinds of civil cases. But what's really important to say here is that until the pandemic began, very few courts used virtual proceedings at all. There were some that had telephonic appearances for certain kinds of routine matters, but basically court proceedings were conducted in person. And very quickly there had to be a rapid adaptation to a situation where either courts were closed and there was no public access at all, or the public access was extremely limited because of public health concerns. So I want to talk about three things. I want to talk about access, which is just simply the how people can get into court, how people can participate in court proceedings. I want to talk about process, which is, I think all of you have touched on, how you make sure that when you have provided access, that the proceedings that are held are fair and they accord with principles of fairness and due process, and the people get heard. And I want to talk about transparency, which is how you make sure that the proceedings are public and that there's some accountability for what happens in those proceedings. So the big problem with access was that very few courts were set up to accommodate the pandemic. They said the courthouses weren't big enough. People didn't have the health measures in place. And most of the courts in our country didn't have the they didn't have the technology to suddenly go to electronic access. And in some cases, there were actually rules that prevented it. The federal courts had a rule, still have a rule actually, that criminal proceedings cannot be televised, that there can't be any cameras in courts for criminal proceedings. And that rule had to be suspended. It actually required legislation to suspend that rule so that criminal proceedings could take place during the pandemic. But there was a need to very quickly provide video access, or at least telephonic access to proceedings. And there was a mixed performance in terms of what courts could and could not do. Some courts were able to do it pretty quickly. They had the resources. It was just a matter of setting up the Zoom platform or some other platform like that in the courtroom. And some didn't have the money, or they didn't have the machines to do it. There are parts of the country, even in the US, which is a very developed country and mostly urban at this point, there are still rural parts of the country that don't have enough bandwidth for Zoom or this type of technology. So there were some real problems with access. And then there was a big distinction between civil and criminal, and that starts to touch into the area of process. But there were areas where in civil cases, there's very little that can't be done virtually if you decide to do it. There's nothing where the Constitution or the law requires that the proceedings be in person. It's more a matter of having the capacity and figuring out how you're going to do it. But in a lot of the criminal matters, it wasn't possible as a matter of law or a matter of the Constitution, that the right of criminal defendants to confront their accusers and the idea that important proceedings in criminal cases have to take place in person. That's been a real struggle for our courts. And the way that it has been dealt with has been that the courts that have had the capacity have prioritized their criminal cases and tried to make do with them. They've tried to provide extra space in courthouses. They provide safety measures, public health measures in courthouses so that people can appear in person. Most of the states and the federal courts have provided that a criminal defendant can waive their appearance. They can agree that voluntarily that they don't have to come and they can appear online. We haven't had the problem that a number of you talked about, where people have abused the process and have tried to use it to avoid having to reckon with their criminal cases. But I think that's because the courts have been pretty careful, to the extent that they've been able to have live proceedings at all. Criminal cases have gotten priority. And so there has not been a major disruption of the flow of criminal cases. I think what has happened, though, is it takes longer for criminal cases to get to trial, particularly affected cases where people are being held in custody if they're in jail pending trial. And that's not most of our cases. Most people are out on promises to appear, but people who are in jail awaiting trial spend more time in jail because it takes longer to get cases to trial. And so it's been difficult to get cases tried in a timely manner. And it's particularly hard in our system, and we're one of the few countries in the world that has juries in criminal cases. And so when you have that, then you have to have extra room for juries and for jury selection. So it's been very, very challenging. On the civil side, most of the courts have found ways for people to appear virtually. And so a lot of civil cases are being handled through virtual platforms. Trials, not so much. If the parties will agree to have a remote trial by a judge, then there's not a problem. But in civil trials, most civil trials, there's also a right to a jury. So that can end up causing delay. And sometimes people want to delay trials, so they just don't agree. So we're able to do it, but I would say that when the pandemic is over, there is going to be a very significant backlog of civil cases. So this is just mentioning the access, not talking about the quality of what happens, but just the ability to have a hearing at all. I think the quality of what takes place, the process issues that all of you talked about in one way or another, I mean, that's been the part that everybody's trying to figure out. What kinds of proceedings are okay to do this way, where you don't really lose anything if you conduct the proceeding virtually, and what kinds of proceedings suffer from not having in-person contact. And I think there's a lot of thought being given to this. I think it actually would be something that would benefit from some research, and we're starting to get some data now because we've been doing it long enough, and other countries have been doing it long enough. But what I've heard from lawyers is that they like being able to appear remotely for routine proceedings because it saves them time, it saves them money, it makes it easier for them to plan their lives. But that for more important proceedings, for major hearings, for trials, for conferences with the court that may lead to settlement of the case, that having the in-person contact is important, and that they miss it, that they don't feel that the virtual contact is as satisfying or as productive. The judges feel similarly that they are able to do routine things pretty well virtually. If it gets more complicated and more serious, then their feelings about it are more mixed. There are judges who have conducted very significant trials, civil trials almost exclusively, entirely virtually, and everybody is satisfied with the result. But the main thing that made that work was that everybody agreed, that the judge and the lawyers and everybody agreed that it was important to get that case tried, and everyone agreed to the virtual platform. If people have to do it when they don't want to do it, then I think there ends up being more of a sense of dissatisfaction and more of a sense of missing something in the process. In criminal cases, it's been even more challenging, just as the access is more challenging. How do you conduct a criminal trial? If you have it in person and you need to take public health measures in the courthouse and people are wearing masks, if witnesses are wearing masks or judges are wearing masks, how do you provide for the kind of cross-examination and assessment of the credibility of witnesses that you would get when you're used to seeing people's faces, when you're used to seeing people's body language? If you do a criminal trial virtually, then how do you make up for that, the lack of that in-person opportunity? So I'd say that it is more problematic on the criminal side, not just in the sense of getting people to appear, but also making sure that the proceeding itself is what we come to think of as a fair trial, where the defendant has a chance to see the witnesses and their lawyer has a chance to question the witnesses and the judge has an opportunity to evaluate the witnesses, that it's harder in a virtual forum than it is in a live one. So we've had to do it, and there are courts, particularly in the state courts, that are doing a lot of criminal trials, and they're getting a lot of data now on exactly how it's gone, what the judges think, what the lawyers think, what the jurors think. But I feel, in trying to give an overview, that I'm not sure how well virtual proceedings work in criminal cases. I think their real benefit is in scheduling and conducting administrative type hearings, planning status conferences, things like that. But the actual trial of a criminal case, and when you start thinking about the issues of justice and due process, it's a challenge. And then if you get to the end of the case and there's been a conviction and somebody's being sentenced, I know that I can't really imagine, and I probably in my career sentenced thousands of people. It was always very important to look at them and have them in the room with me, and to have some type of interpersonal contact with them when I was imposing sentence. And the idea of sentencing somebody over a video, particularly if it's a serious sentence, if it's for a long period of time, that troubles me a lot. I did it one time in one case, and everybody had agreed. The defendant agreed, and I had agreed, and the lawyers had agreed, and it saved everybody a lot of time because I was on one side of the country and the defendant was on the other. But even that felt a little strange. It was not what I was used to as a judge. So there's a real challenge there, I think. And then the last thing I wanted to talk about was just the idea of transparency, right? That trials are supposed to be public. The public's confidence in the judicial system depends on being able to see what happens in court and have things not be secret. And so there's a technical challenge, not only in making sure that there's an opportunity for people to participate, have access to the courts, to get their cases heard and to appear in their cases, but some way that the public, which is used to being able to go into the courthouse and watch a case that they're interested in, or having the media cover it, that there's some way to make up for that and to have some sort of public broadcast of what's taking place in court. And that requires more technology. It can be done, but it just means that it's another resource challenge for the courts. They have to have the hardware, they have to have the software, they have to have the technical knowledge. And I think that's yet another challenge that we have. I was going to talk about one more thing. And so this is actually just something that I borrowed from a presentation that I do very frequently for judges about the stress of the job. Because I don't need to tell anyone who's participating in this program that judging can be a very stressful job. It's not easy. And there are particular stresses that come with the job that the judges have to get used to and have to get comfortable dealing with, or else it ends up being kind of an unhappy job. I have some of them up here, and you see some of them are highlighted in blue, and I'll explain that in a second. But obviously, one of the things that creates stress is if you have too much work, and that's something that judges around the world have to deal with. That usually there's more cases than any one judge can handle comfortably. So there's stress associated with just getting the work done and making sure that it's done properly and in a way that is consistent with professional expectations. Another part of the job that's very stressful is that you often are seeing situations where there's a lot of emotion or trauma involving the parties. It's certainly true in matrimonial cases. It's true in juvenile cases. It's true sometimes in civil cases where the parties are very unhappy with each other for one reason or another. It's true in criminal cases where someone has committed a serious crime and has hurt somebody else, or you have victims that have suffered as a result of a crime that was committed against them, or you're sending somebody to jail or prison for a long time and they're going to be separated from their families. So there's so many sources of emotional intensity in the judicial job. And I think, and this is something that I've heard consistently from the judges I've talked to, that when you do virtual proceedings, that it's actually worse, that you don't have, something changes. If you're watching it on a screen, if you're not in the room with someone, if you're not engaging with them in the fullness of your humanity, the way you would normally be, that it actually ends up being harder to process. So I think one of the things that we're seeing with judges is that when they encounter these emotionally charged matters, that doing them virtually actually makes them a little bit harder and more stressful to manage. So that's one point I'd make. Political and social pressures and social media, I don't need to tell anybody here about that. This has obviously been an issue, a regional issue. It's not just an issue in Eastern Europe, certainly it's an issue in the United States too, but it's a regional issue. And I think that's another source of stress. And then concerns about safety and security. Well, that's something that, again, the judges worry about all the time. If you're in the courthouse, you have whatever security the courthouse provides. You have the institutional protections that are there. If you're not in the courthouse, then you're more at risk, perhaps, than you would be otherwise. If somebody can figure out where you live, or somebody can figure out where you go to the grocery store, that your security and safety is more compromised. And that is kind of a low level but consistent source of stress for judges during this pandemic era that we're dealing with. And I think that's another thing to be aware of. The isolation. So isolation is another issue that judges talk about all over the world. You know, that you have a job that, you know, you have to make these important decisions for other people, and they're hard sometimes, and you go through emotional turmoil sometimes in dealing with them. And the job is kind of an isolated job. You don't really have a place where you can talk about what you're experiencing. Most judges don't. That's worse if you're isolated in your home. You know, if you don't have the community of your colleagues in the courthouse, that stress has been magnified by the pandemic. And then I'll just skip over these others at the end. I mean, most of us who become judges have a certain kind of character or temperament. We tend to be high achieving people and have high expectations of ourselves and a tendency toward perfectionism. And all of those things cause stress. I mention that only to say that in addition to the technical challenges, how do you provide access, and the judging challenges, how do you provide fairness and due process and dignity in this type of remote proceeding, and the challenges of transparency, how do you make sure that the public understands what's taking place and make sure that they're seeing it. There's also, I think, personal challenges that judges experience as people. And I think that that's an important part of this analysis. Thank you.
Thank you so much for your presentation. Extremely helpful and a great start to the course. Radi, I hand over to you.
Thank you, Rachel. Hi, everyone. Just a second. I am extremely grateful to be given the opportunity to take part in this course and to meet all of you, though from a distance. I am highly interested in the matters of electronic justice, both in my country and abroad. During today's presentation, I will touch upon the issues of the new challenges that judges face in a situation of pandemic, and will share my personal experience in the last couple of months. I will also present my views on the future development of technologies in the judiciary and the associated benefits and risks. The year 2020 left a significant trace in the lives of each of us. It changed the way we communicate, the way we live and work. It even changed the way we think. We witnessed different reactions from each country to the new challenges, which also affected the measures taken in the judiciary systems in the European countries. It would be interesting for me to hear what kind of measures have been taken by the courts in your countries during our discussion a bit later on. And now, shortly, let me mention a thing or two about the situation in Bulgaria. As a reaction to the pandemic and the first registered cases of COVID-19 in Bulgaria, the government announced a state of emergency of March 13th, which continued for 2 months. In an attempt to protect the health of the judges, the court officials, and the citizens, the Supreme Judicial Council immediately adopted emergency measures applicable for all courts. In practice, during these 2 months, it was forbidden to hear almost all civil and criminal cases. The only exceptions were made for cases concerning arrest and house arrest, permission or approval of search and seizure, implementation of medical measures against mentally ill persons, cases concerning domestic violence, child care, etc. During the first month of the state of emergency, my court, which I said is the biggest court in the capital of Bulgaria, even stopped initiating court cases. All hearings were adjourned, and me and my colleagues, if we weren't on duty, were not permitted even to enter the court building. We were only allowed to enter once a month in order to announce the acts we had drafted at home and to take new case files back home. Such measures are unprecedented, and it was obvious that the judiciary was not prepared to react to the pandemic. This was mainly due to the fact that since up to this moment, the opportunities for conducting remote court hearings had been used extremely rarely. At present, the judges in Bulgaria do not have distant access to the case management systems of the courts. Unfortunately, in the newly created single information system, which has been implemented in the last couple of months in all courts throughout the country, such access is also not planned. So this has created extreme difficulties for the judges to do their job remotely. For this period of 2 months during the court's closure, judges could only draft court decisions and motives to verdicts only after resuming the normal course of work in the courts in mid-May. There was finally an opportunity to schedule cases anew, to get acquainted with the newly initiated proceedings, to rule on current issues, and to conduct court hearings according to the set public health measures. During and even after the state of emergency, immediate measures were taken to provide appropriate technologies allowing to conduct at least the emergency court hearings. The most used tool was definitely a video conference. Video conference with the prisons, arrests, or psychiatric yards was made in order to ensure the participation of the detainees in the proceedings without them being transported to the courtroom. The remaining participants in the proceedings, however, a judge, prosecutor, attorney, witnesses, all had to appear in court in person. Other tools of electronic justice, which partially have seen a wider use, were the more frequent usage of phone calls, emails, and providing materials to the parties electronically. However, these were done without making full use of the capacity of e-justice or remote judging. At present, the work of the courts has gone nearly back to normal. All court hearings are conducted with the physical presence of the parties and witnesses. The only significant change and limitation is the prohibition to have numerous persons as audience during the court hearings. That includes representatives of the media too. Though, in order to ensure publicity of court hearings with high media interest, each court has taken different measures. Some courts have decided to allow a couple of media representatives in the courtroom, but with no right to record or broadcast the hearing, especially in criminal cases. Other courts have decided to allow broadcasting of video or audio signal from the hearing. I think this was the Supreme Court in Bulgaria, even in a special YouTube channel. Or alternatively, some courts provided a written script to the media immediately after the court hearings. Thus, balance is sought between the public health measures and the constitutional principle of public court hearings. I believe that this is somehow the Bulgarian answer to the questions recently raised by Yelena and Pavlo in our forum. And at the moment, the use of video conference in criminal matters is mostly limited to some cases of detainees or expert and fact witnesses placed under quarantine. Video conference with a party in the proceedings, most often this is the defendant, is the only measure widely used as an example of remote judging currently. This is why I would like to elaborate on the challenges of using it in criminal proceedings. Firstly, it's good to know that this opportunity was stipulated in the Criminal Procedure Code almost 15 years ago. But until now, it was mostly used for interrogation of fact and expert witnesses who are abroad or cannot be present in the courtroom. However, if the defendant participates in the hearing via video conference, which is allowed by the Bulgarian law, there are some special issues to be concerned. The procedural guarantees for the rights of the accused during their physical absence from the courtroom must be ensured. The court must provide the defendant with an opportunity to get to know the case materials in advance and the evidence submitted by the other party in the course of the hearing. For instance, this is possible by scanning them and sending them to the defendant via mail or performing examination of physical evidence in front of the camera, or maybe arrange for the defendant to actively take part in the interrogation of witnesses. It is of crucial importance also to present the defendant with an opportunity to receive timely attorney assistance, including keeping the attorney-client privilege and confidentiality. that could be easily provided by a telephone conversation between both during the hearing, shall they need to privately discuss defense strategy or other important matters. And of course, if they both agree to do it. This example can provide some insight to the question raised by Olga in our common forum. Personally, I have also conducted trials with the remote participation of the defendant, and the whole process went smoothly, although, of course, it was a bit strange for all participants. It is obvious, however, that video conferencing represents a very limited use of opportunities provided by remote participation in court hearings. We need to work further to arrange for all parties, witnesses, interpreters, and even the court panel to participate in the hearings and to have access to materials remotely outside the courtroom. That will prevent another full suspension of the court's work in the future. This would be possible only if the case files become entirely electronical and the parties would be able to access them. And in Bulgaria, currently, we don't have access to these resources. Furthermore, a secure and protected technical connection needs to be ensured between more participants in the proceedings, which at the moment is also not available everywhere. To share with you, in my court, we are even using basic free Skype accounts to organize remote participation in the process. It is necessary to work towards creating opportunities for the judge to rule remotely on urgent requests for permission or approval of actions in the pre-trial phase or routine matters in pending cases. Unfortunately, the road is long and difficult, at least for the Bulgarian judiciary, but I think we all have the same problems. But I do hope that the governing bodies will realize the huge benefits that a fully functioning e-justice provides, especially in times of pandemic. To name a few benefits, introduction of measures for effective e-justice will provide not only a greater transparency of the judiciary, but will also lead to significant economic savings for the government and the citizens alike, while taking due account of the environmental aspects of the reform. However, the implementation of technology in court systems depends on a complex interplay of factors, among which budgetary, cultural, political, both within and outside the court system itself. There are changing social and political contexts, including demographic of court users, increasing demand for transparency and accountability, greater expectations on the ability to access information and interact with the court remotely, as well as searching for a more secure way to take part in the court hearings. As courts embrace the advantages of remote judging, it is important to preserve the dignity and solemnity of the court as an institution. Though the benefits of virtualization are self-explanatory, courts' decisions in this area must also take account of any wider impact that might be expected, like distancing the judiciary from the community it serves and restricting access to justice for some individuals. To conclude with, new safeguards for judicial independence must continue to evolve as courts adopt new ways of working. The most important factor for the future development of the courts, it is not the technologies used in courtrooms. Rather, it is the people who work in the courts, and especially the judges, the courtroom staff, the members of the governing bodies of the judiciary. The court is there to serve its community, and we should understand, react, and respond to the changing needs of that community and the ongoing pressure of legislative and public health demands. Our reaction will determine whether the courts in the next decade will keep pace with modern times and fulfill their constitutional role to guard the rule of law. That was my presentation. So thank you for your attention. I hope I have managed to shed some light on the current situation in Bulgaria and my personal view on e-justice. And now I am looking forward to hearing your thoughts on this subject. How far do you think we should rely on remote judging or e-justice in general? What kind of challenges have you experienced in your work in the last 6 months? Would you please share with us? Thank you.
Thank you so much. And thank you to you both. I can't think of a better way to begin our course. I think you covered many of the issues that people have already raised as wanting to be discussed throughout, and actually some examples of practical ways in which the challenges can be overcome and addressed. So I'll hand over to Jeremy first, if you'd like to pick up on any of the questions.
No, I do, and I thank you. And I really want to second something right at the end of Radi's presentation that I think is so important, and that is why we're doing this. Who is this for? And sort of the role of the courts is to serve public, right? It's to serve the community and to provide a forum for resolution of disputes. And I think what happens is there's so many other interests involved besides that one. And we were presented with this situation that nobody anticipated. We're just kind of going along, and then all of a sudden there's this worldwide pandemic, and it disrupts everything. And I think not just courts, but institutions all over the world have been trying to figure out what they can do to respond. How do you get your work done in these unprecedented conditions? And one of the ways courts have tried to respond is by using technology more than they ever have before. And it's a work in progress. It's very uneven. I mean, there are some places that are using technology a lot and others that aren't using it very much, and some are using it in criminal, and some are just using it in civil. But when we get to the end of this, or even as we get to the end of it, even before we do, we need to look at what we've learned, and we need to think about, all right, what in here is worth keeping and institutionalizing, and what isn't? What has been the impact of this on our life? And we kind of get out of crisis mode and we get into looking forward and thinking about how to make our courts better. And I think the interest that has to be the predominant interest is the one that Radi said. And how do you serve the community better? How do the courts perform their service role better? And there are a lot of ways that technology could make judges' lives easier or harder. I mean, there are ways that technology could end up putting a tremendous strain on the budgets of courts. There's ways that technology could improve or not improve public access and public trust and confidence. But in making these kinds of decisions, you have to think about, what is your metric? What do you care about the most? And I think that's why it's very useful to remember that the idea is to try to deliver justice fairly and efficiently and without undue expense. And so I do think, looking forward, that there are ways that this catastrophe that we've had, this disruption that we've had, actually could make the courts better, that there are things that judges can do remotely that will save everybody time and money and inconvenience. I know in the cities in my country that if you have a relatively minor matter and you need to go to the courthouse to appear in that matter, you have to drive into the center of town, you have to find a place to park, you have to pay for parking, you have to go into the courthouse, you have to get by security, you have to wait for an hour or 2 or 3 to have your case heard. And a lot of people just don't even bother because, why am I going to do that for a small claim or a matter that really doesn't matter that much, a debt collection? And one of the things that has happened since we have had more virtual proceedings available is that more people show up, that people can be in their home and they can log into a virtual proceeding and they can participate in it. And that's a good thing. We've had more participation. There's another aspect of Zoom, which I find kind of amusing and is probably worth studying, but in many courthouses around the world, the architecture of the courtroom is set up so that the judge is in an elevated place and the whole setup is kind of intimidating and kind of remind the parties, that they're not the people with the power and the judge is the person with the power. And Zoom, everybody's box is the same size. And there's something about the psychology of that's really interesting and worth thinking about. But on the other side, at least I think I made clear earlier, I don't think it's in our interest as a legal system to not give people an opportunity to appear in court and speak directly to another human being about their situation. So, it's finding the right balance. And we are kind of in an experimental phase right now where we're being forced to do things we might not otherwise do, because if you don't do it, then nothing happens at all. The courthouses are closed or people get sick or, there are other unacceptable outcomes that you don't want. But I guess my thought that I want to add here is it is about public interest, and it is part of our job as a judiciary to really be reflective about our experience and think about what would be good in the long run, not just what's going to get us through the emergency.
Thank you so much. And I think those are really crucial points to reiterate. I'll hand back over to Radi for any comments she wants to make or any comments in relation to the questions that were posed in the forum.
Thank you, Rachel. I totally agree with what Jeremy said about how important it is to find the balance between all pros and cons of the new technologies used in court. And I guess it's important also to take into consideration what type of court users do we have in this region or this type of court or this country, community, city, because there are huge differences even in one country. And of course, in criminal matters, the questions are even tougher. I'm a true believer that we will use this time to rethink the way justice is done and maybe to modernize it. And I hope that will be better next year. Because we should always think that millennials are also our users and they prefer Zoom meeting rather than coming into the court. And this is also important. Of course, there are people, they don't have access to internet or modern technologies, and it's impossible to have only remote judging, only remote hearings. But still, if it's okay with the users, with the parties, I think we should try to have more wider use of that. I believe, especially in criminal matters, that only if the parties agree, there should be remote participation in the process, especially for the defendant. And in Bulgaria, now, during the pandemic, all the detention hearings were via video conference. And this is the only exception made for the right to personal appear in court. But now, of course, if they prefer, all detainees could come and appear in person. And of course, for the defense lawyers, I think it's also very important question. Should they be obliged to take part in the process remotely if, let's say, the lawyer is under quarantine? It's okay to postpone a case once or twice if that's not done regularly, but still we should think more for the rights of the defendant
Right.
than the timely proceedings. And
I agree with
case.
that. And I think
Yeah.
it's a balance again.
Yeah.
You know, if you have a truly urgent need, not just the judge
Yes.
wants to have the hearing, but I mean, you know, let's say there's a public safety issue or something like that, that you might want to say, no, we're going to go ahead and the attorney can appear virtually. But I agree with what you said as a general rule. And there's some interesting data that for detention hearings, that this is in the US, that defendants get detained more often after virtual hearings than after in-person hearings. So that actually judges will detain defendants more often if it's a virtual hearing. It's not a big difference, but it does make a difference, right? So
Yeah, I guess it's true.
So you know, when you're a judge and you're thinking about this, you want to move your cases, you want to get the case over with, and you may even not particularly trust this lawyer. You know, maybe they're always moving for delays for this or that. But you know, it's in every case, it's like trying to figure out what are the equities, what's the balance that you have to achieve. And I agree with Roddy that in a criminal case, that the rights of the defendant really are kind of, you know, you can't just water them down because you're able to do it using a virtual proceeding. Whereas in a civil case, I wouldn't hesitate quite so much.
Yeah, or if the parties agree, it's not a problem. But
absolutely, parties agree, I don't have a problem. If they want to have everything virtual, then fine, if they agree. Yeah,
this is the important thing.
Right. There was a rule that prohibited video criminal proceedings. There was a federal court rule that prohibited video in criminal proceedings. That rule has been suspended because of the pandemic. So I don't know what's going to happen afterwards. So during the current time, it is something that the parties can agree to. In the state courts, each state has its own rules and its own constitutional principles. In the state court that I was a judge in California many years ago, actually it was fine to have cameras in the courtroom. It was one of the first jurisdictions that allowed that. So it happened pretty regularly and certainly could be done by agreement in a criminal case. So it depends where you are. The federal courts are going to have to decide whether they want to continue suspending the rule that bans cameras. And I really don't want to make a prediction on how that's going to happen. I personally think that what they should do is they should permit the parties to agree. I don't think that solution harms anyone. I
may add that in Bulgaria, it's prohibited to have a video of the criminal hearings, and this prohibition is still working now. So that's why only audio signal is possible to be broadcasted from a criminal proceedings. I have a personal experience with that. I had arrest hearing with 4 detainees accused, and they were taking part in the proceedings remotely from the arrest building, and there was a media case, and a lot of journalists wanted to visit the courtroom, but it wasn't allowed. So I allowed only for 2 to enter. And then we broadcasted to a closed group of journalists only the audio signal, because our constitution says that it's prohibited to take picture on someone if he doesn't agree. And the problem is that the accused can't say no because he's in the courtroom and he has to be there. That's why we decided not to allow that for criminal matters. But for civil matters, I think there is not a prohibition for that. So in Bulgaria, I wouldn't allow it even if the parties agree to do it. I think the process is different when it's broadcasted.
Yeah.
Let's say that way.
I'll answer it for the US. I can't speak to the ECHR. Our Constitution provides for a right of confrontation, and that's been interpreted as meaning that the defendant has the right to be present physically at any proceeding that could just be dispositive, that could affect the outcome of the case. So they have the right to be at their trial. Certainly, they have the right to be at sentencing. They have the right to be at any proceeding where a judicial decision might be made, and they might have something to say about it. So it's a constitutional right. It's not. I kind of agree with the premise of your question that I wish we had more latitude, but that's the problem we have.
For me, it's more like a principle to the right to have a fair trial, and I want to ensure that during the cases I hear, this principle is guarded. So if the defendant wants to take part in the process, being in the courtroom, then I think we should guarantee that right. I don't know if there is a decision of the European Court having to say with that, but in Bulgaria, it's not only a right, but also an obligation for the defendant to be present at court for the more severe cases. So that's why I think it's better to give him a chance to come. If it's possible, of course. If he violates his rights, then he can be detained and he will come eventually.
Thank you so much. So I think we need to to end it here. I just want to say thank you so much to our 2 panelists, Jeremy and Radi, for these fantastic presentations.